In the matter of Jitender Kalla versus State Government of National Capital of Delhi and others, Justice Abhay Asoka of Supreme Court of India recorded their concerns to enable the Honorable Chief Justice of India to decide whether the doubts expressed in this case need consideration by an appropriate larger bench. The two issues which arose in this case were: the first issue was about the conduct of advocate on record who filed the special leave petition, out of which the present appeal arose. The second issue concerned the conduct of advocate who appeared in this case as a counsel and was later designated as a senior advocate. Two consequential issues arose. The first issue was about the need to formulate a code of conduct for the advocates on record. The second one was whether the decisions of this court in the case of Indira Jaising versus Supreme Court of India 1 and Indira Singh versus Supreme Court of India 2 need reconsideration. The question of taking action against the appellant for making false statements will be considered in a separate application on which notice has been issued. The Supreme Court held that this court is the final court in our country. For the purposes of maintaining the sanctity of Supreme Court and for ensuring the cases are properly conducted, only advocates on record are entitled to file a case or a wakalatnama for a party. It is only through an advocate on record that a litigant can seek justice from the court unless he wants to appear in person. Therefore, the role of advocate on record is very crucial. As highlighted by Dr. S. Muralidhar, the learned senior advocate, it is true that in day to day practice, advocates on record get petitions, appeals, counter affidavits drafted by some other advocates appearing in the cases either before the trial court or the high court. Sometimes they receive case papers and have a kalatnama for filing petitions, appeals, counter affidavits through an advocate practicing at a trial court or high court or from a litigant. Therefore, in such cases, the advocate on record may not necessarily meet his client. The role of a designated senior advocate in our legal system is of considerable importance. Those who are designated senior advocates have a different status and a high standing in the legal system. Therefore, it is imperative that only those advocates who deserve the designation in terms of subsection 2 of section 16 should be conferred designation. If undeserving candidates are designated as senior advocates, it affects the prestige and dignity of the institution of the judiciary, as it is the privilege of the high courts and of this court to grant such designation. Therefore, it is imperative that the best possible system should be devised for the process to be undertaken in terms of subsection 2 of section 16. Ultimately, the endeavor of all stakeholders must be that we should have a system in which only deserving advocates get the designation. It is true that the overall assessment made by the permanent committee in terms of points is placed before the full court. The decision of the full court may not necessarily be based on the points assigned by the permanent committee. Still, the full court cannot altogether ignore the assessments made by the permanent committee. When the point based assessment is not free from defects, the question is whether it can form the basis of assessment of an advocate. Another issue is about the prohibition of secret ballot. The judges consider the applications in full court. The question arises as to whether the judges should openly discuss the merits and demerits of those candidates who appear before them on the judicial side. Therefore, the issue of permitting voting by secret ballot needs serious reconsideration. There is one more serious area of concern: whether the guidelines give sufficient opportunity to the advocates practicing in trial courts to get designated. There cannot be any dispute that we have very eminent lawyers practicing exclusively before trial courts who have the ability, standing, and experience in law. They are outstanding public prosecutors and defense lawyers. In most cases, their arguments may not always have legal formulations as reflected in the judgments in cases where they appear. The submissions will necessarily be based on facts. They will not have reported judgments to their credit. The court thus concluded that when a petition or appeal is not drafted by advocate on record, the advocate on record who files it is entirely and wholly responsible to this court. Therefore, when an advocate on record receives a draft of a petition, appeal, counter affidavit from any other advocate, it is his duty to go through the case papers and thereafter to carefully go through the petition, appeal, or counter affidavit to ascertain whether correct facts have been stated in the draft and whether all relevant documents have been annexed to the petition, appeal, or counter affidavit. After reading the case papers, if he has any doubt, he must get the doubt clarified either by contacting the client or his local advocate. He is responsible for ensuring that he gets correct factual instructions so that there are no suppression of facts while filing petitions, appeals, or counter affidavits. An advocate on record is answerable to Supreme Court since he has a unique position under the 2013 rules. Therefore, when incorrect facts are stated in the petition, appeal, or counter affidavit, or when material facts or documents are suppressed, the advocate on record cannot shift the entire blame on the client or his entrusting advocates. Therefore, it is his duty to be cautious and careful, his duty to file proper proceedings and affidavits before this court to assist the court in dispensing justice. He must always be fair to the court and effectively assist the court in deciding cases. The duty of the advocate on record does not end after filing a case or a counter. Even if the counsel appointed by him is not present, he must be ready with the case on law and facts and effectively assist the court. It is the obligation of the advocates on record not to merely lend their names to the petitions, appeals, drafted by somebody else. If they do that, the very purpose of making a provision for setting up the institution of advocate on record will be frustrated. If advocates on record start behaving irresponsibly and start merely lending their names while filing petitions, appeal, counter affidavits, it may directly impact the quality of justice rendered by this court. Therefore, if any advocate on record commits misconduct or is guilty of conduct unbecoming of an AOR, an action against him as per Rule 10 of Order 4 is warranted. Regarding the designation of Shri Rishi Malhotra, it was left to the Honorable Chief Justice of India to take a call. Supreme Court also highlighted various suggestions of the office bearers of Supreme Court Advocates on Record Association. The suggestions were regarding the conduct of examination of advocates on record. There are suggestions made for adopting a consistent approach regarding notifying the deficiencies and objections in the cases filed. They want bottlenecks to be cleared in filing the registration and verification of cases, which may result in early listing of cases. Their contentions are that there is no written handbook available containing instructions regarding the process of checking and verifying newly filed cases. The norms and criteria keep on changing at the whims and fancies of the registry officials. Therefore, the suggestion of the association is that Secretary General or registrars should regularly organize open houses in which healthy discussions can take place on the processes adopted by the registry. Perhaps this suggestion is welcome as there can be constructive dialogue between the association and the registry for the purpose of clearing bottlenecks and ensuring early listing of the cases.